No, it's. Vic, what page?
Page 18,
Got it.
Marquez.
Good morning, Mr. Marquez. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 17, 2025, the officer was dispatched to an assault. Upon arrival, the officer met with the complainant, who stated she and the defendant have been in a dating relationship for 11 months. The complainant then stated the defendant has been continuously assaulting her, and she showed surveillance video of the incident to the officers. The officers observed the defendant grab the complainant by the hair and strike her several times in the face with a boxing glove. The officer also observed the defendant get on top of the complainant and pin her down, striking her in the face, and the complainant advised she felt pain from all the strikes. The officer observed the complainant to have visible abrasions on her left shoulder and bicep, along with redness on her face.
He just had an assault that was dismissed in October of this past year.
Yes,
Is this the same complaining witness? Okay. Mr. Marquez, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to have any contact with this person whatsoever. I'm issuing what's called a magistrate's order for emergency protection, which is a court order that identifies Ms. Rubio as a protected individual. You're not to commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code. Is a stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of the Melbourne Street place. Do you understand?
Yes, sir.
I want you to understand that I'm going to protect every single person in this county by all means necessary. You endanger my public, it's not going to go well for you. Felicia, I want to make sure that he's not consuming alcohol or drugs. I'm going to randomly test you. If I find that you're using alcohol or illegal drugs, likewise, I will revoke your bond, put you in jail, make your bond very high. Do you understand?
Yes, Judge, the milk was signed last Friday. A magistrate court. On the 18th, or last Saturday, actually. You scroll way to the bottom.
Okay. So it looks like a protective order has been issued. I would get to know it because if you violate this protective order, the state can and will file a violation protective order. That is a capital murder of misdemeanors. Do you understand, sir?
Judge, the magistrate also did order a GPS device that was
Yep.
installed prior.
I'm okay with that.
I have it on, sir.
Did you want do you need a lawyer, sir? Okay. So you don't want a court appointed lawyer then? Okay. I'm going to have you sign a reset. After that, we'll get with Felicia for your bond condition. After that, you're free to go. Don't violate these conditions, Mr. Marquez. It's not going to go well for you. Do you understand? Okay, come on. It's fair. You are charged with assault, bodily injury. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Yes, Judge. On January 3rd, 2025, the officer was dispatched to a disturbance at a residence in Harris County, Texas. Upon arrival, the officer met with the complainant, who knew the defendant as his sister-in-law. The complainant stated the defendant came to his residence shortly after a verbal dispute with his child's mother, and the defendant arrived and told the defendant told the complainant to come outside and meet with her boyfriend. When the complainant stepped outside, he was assaulted by the defendant by a closed fist to the back of the head. The complainant stated the defendant continued to strike him in the back of the head before he began stumbling down the stairs. The complainant was then assaulted by an unidentified black male while still being assaulted by the defendant and the defendant's sister. The defendant was gone on arrival, but was contacted via a public service by the officer and was ordered to return to the location.
Did the other person get arrested as well?
It appears there is a connected case, Your Honor.
The sister was also arrested.
So we have 3 co-defendants or
No,
2
just
co-defendants?
Yeah, just the sister,
Okay.
Your Honor.
Do you know of alcohol or any kind of,
There's no allegations, Your Honor.
I see that she's on probation as well. Ms. Fair, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm also ordering you not to be in possession of weapons, not to have contact with the complaining witness in this case, and not to be in contact with any of the co-defendants. Do you understand? Yes? Okay. If I find that you violate these conditions, I'm going to revoke your bond. I'm going to put you in jail. I'm going to protect my community at all costs. You understand, ma'am? You need a lawyer, ma'am. Okay, Ms. Fair, I need you to fill out an application for me I'll provide you a lawyer after that. Don't violate these conditions. Do you understand that? Okay, please. We'll have you sign a receipt. You'll get with Felicia for your bond conditions, and then we'll have you fill out an application.
I spoke with the complainant and
Ma'am, hold on. Come back up.
he's no longer living, he still has the lease to the residence of the 1180 Grant Road, but he's not living there anymore because the co-defendant lives there. He's actually living at his sister's residence, so if we could get a restriction, like a.
Sure, just provide it to Felicia so she knows, and then we'll put that in the order as well, that she's not to go to this location.
Yeah, Judge.
Okay, ma'am, please.
The 14 judge.
Mr. Jackson, you now stand charged with another case. You were charged with possession of marijuana. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes. On January 18, 2025, the officer observed the defendant's vehicle traveling 78 miles per hour in a 60-mile-per-hour zone, have an expired registration, and failed to maintain financial responsibility on Interstate 45. The officer noticed a prominent odor of marijuana trailing the defendant's vehicle, and a traffic stop was initiated. The officer observed the defendant to be in the driver's seat with a black bag and a female to be in the front passenger seat. The defendant rolled down the passenger window, and the officer observed a cloud of smoke emitting from the vehicle with an odor of marijuana. The defendant was asked to step out of the vehicle with the black bag. The black bag was opened, and the officer observed a clear jar with a green leafy substance known to be marijuana based on training experience, along with a digital scale and individual baggies. The defendant was searched for weapons, and the officer found more packages of marijuana inside his private area. The weight of the marijuana was 1.82 ounces.
And Your Honor, if I could adjust probable cause.
Okay,
Your Honor, so while I don't dispute the reason for the stop here, I think there's a couple things that stand out. So there is a alleged smell of marijuana that comes from the vehicle, and then an alleged cloud of smoke that comes from the vehicle as the windows are open. So first off, the officer doesn't specify whether this is a cloud of course, burnt marijuana, which I would assume, or vaped marijuana, because those are two very different things with two very different distinct smells. Additionally, if the officer is pulling him out and looking for marijuana and he has this cloud, then he would be looking for burnt marijuana, right? So he would be looking for a roach. He would be looking for a blunt. What he does is he looks inside of a plastic bag. If we have embered marijuana or we have a lit blunt, it's certainly not going to be in a plastic bag without the smell of burning plastic. Additionally, the marijuana that is found in the bag is in a sealed glass jar container, something that would not emanate a smell because a glass jar is essentially smell proof. In this instance, I think we have an officer who went too far with the search because we have Mr. Jackson here who did not admit to possessing marijuana, did not admit to this being marijuana. The statute, of course, requires that this has to be marijuana, and we know we have the issues, of course, with the hemp bill. But Your Honor, if you're not aware, you can go into any head shop, purchase flowered hemp, open it, and it smells, looks, everything about it is identical.
I understand,
to
and that,
marijuana.
yes, I agree with you for a beyond a reasonable doubt standard, but here, this is just mere probable cause, right? There's a good stop, goes to the car, smells marijuana, there's a plume of smoke that comes out. Not only that, Sean, he signed an affidavit that he wasn't going to drive. He's not supposed to be driving regardless.
And I get the driving aspect of it, but I don't see how a cloud of marijuana from burnt marijuana gets you inside of a plastic bag. At that point, it becomes a fishing expedition as opposed to looking for the actual contraband, which he suspects that would be in the vehicle.
I don't know. I mean, I think that there's certainly enough to go forward. Beyond a reasonable doubt, I don't know. But this is just a probable cause standard, which is the low stand, So
I understand.
I'm going to find that there's probable cause to go forward with your case, Mr. Jackson. I ordered you not to drive. He's the driver in this car?
Yes, Judge.
Okay. I'm now revoking your bond. Goes with you. Sorry, Sean, but he promised us he's not going to drive. He signed an affidavit. He knows. He knew.
And Your Honor, will a new bond be set? And if so, can we get that amount set?
Good morning, Mr. Humphrey. So you're charged with harassment. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes,
You have
Judge.
the right to have an attorney present. If you're not for one will be appointed to you.
Yes, Judge. The officer was conducting a follow-up investigation and spoke to the complainant. The complainant knew the defendant by name and sight as they were in a dating relationship for 2 years. The complainant stated they ended the relationship in 2023, but continued to be friends because they worked in the same building. The complainant stated she initiated contact with the defendant via cell phone. The defendant showed up at her location and talked. The defendant asked to hang out, but the complainant stated she was busy. The complainant left the location and got a call from the defendant, and the complainant told the defendant to leave her alone and hung up. The defendant called her 35 times and called her using a secondary number. The complainant blocked both numbers, and the complainant got approximately 100 calls from a no caller ID number. The complainant answered, and the defendant told the complainant to unblock her, and the complainant hung up. The complainant arrived at her office and saw the defendant calling her and was knocking and attempted to open the door to her suite. The complainant was escorted to her vehicle, and the defendant contacted the complainant 39 times via his cell phone, 1 time via a secondary number, 6 times via email, and 100+ times from a no caller ID. The defendant spoke to the officer and admitted to calling the complainant 100+ times from his primary phone number and his secondary number and sending emails because she blocked him.
Mr. Humphrey, I'm going to find that there's probable cause to go forward with your case. You're on bond for murder. You now picked up a harassment case. You're lucky to be out on bond. Now you picked up a new case. I mean, really. I'm ordering you as a condition of your bond not to have any contact with the complaining witness. I'm going to put a GPS monitor so I know you're not going anywhere near this person. I will protect my community at all costs. Do you understand, sir? You're not to consume alcohol, illegal drugs. I don't want you going within 1,000 feet of where she lives, where she works, no weapons. You know, life is really short. It would really suck to spend the next 50 years in a 6x9 box. There's so many fish in the sea. It's not worth it. You know what I mean? Really. Move on. Just life's way too short. Really. Do you have the ability to hire a lawyer, Mr. Humphrey? Or do you need a court-appointed lawyer? Okay. Just, I want my community safe, man. That's all I want. Please, you know, please. I have an application on file already. So I'm going to have you sign a release of Victoria. I'm going to have you meet with police for your bond conditions. I'll provide you a lawyer here momentarily. Just think before you act. Come on.
Judge, would you like me to mirror the
Cell phone number so I can give it to the lawyer, please. You need a pen? Here. If you don't mind, give me your cell phone number so I can give it to the lawyer, and then I'm going to have him reach out to you here momentarily. You guys need to get on the same page today. You need to stay in contact with him, and he'll tell you when you have to come back to court. Don't pick up any new cases. You already know what's going on. Okay, please. No. We just write it because I don't want to.
Does it end in 591? Your number?
No, you said does it end in 591?
Yes.
It end in 91.
So yeah, what are the last 4 digits?
Oh, yeah.
3591.
Yes, I have it.
Okay, don't worry about it. So this is Abel. He's going to reach out to you here momentarily so you guys can talk about the case. Or it's going to be on the reset we give you. We're going to give you his number now.
I did just call his number and it went straight to voicemail. I'm assuming he has his phone off.
Sorry.
Okay, so regardless, I don't have you attached to the case yet. Let me see. Do you have him attached to the case yet, Vic?
No, but I'll write his number on the reset.
Okay, we're going to give you his number. It is your responsibility to stay in touch with him. I'm going to waive your appearance. You don't have to waste your time coming to court, but stay in touch with him and he'll tell you when you have to come back. If he tells me he can't get a hold of you, I'm going to revoke your bond. You pick up a new case, I'm going to revoke your bond. Just be good. Don't have any contact with this person. I don't care what's going on in your life. Don't contact this person. Do you understand?
Sure.
If she tries to contact you, don't answer the phone. If she texts you, don't reply. If she comes to your house, don't answer the door. You're the one that's going to be sitting in there. All right?
Sure.
All right, come on. Thanks, Abel.
Right this way.
Thank you, guys.
Does it?
Oh.
Go ahead and sign, please. Go ahead and save her behind you.
Okay. Signed. You are Jonathan Caldwell. Mr. Caldwell, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 13th, 2025, the officer observed the defendant's vehicle traveling 35 miles per hour in a 20-mile-per-hour zone on Pine Dust Lane. A traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle, and the defendant was not wearing a seatbelt. The officer further observed an odor of marijuana and asked where the marijuana was located. The defendant stated the marijuana was located in the back seat. The defendant gave consent to search the vehicle, and the officer found a clear plastic sandwich bag with a green leafy substance in the back seat and a glass container with a green leafy substance. The total weight was 0.921 ounces.
Okay, Mr. Caldwell, I'm going to find that there's probable cause to go forward with your case. Have you looked to see if he has a license?
It's not eligible, Your Honor.
Okay, you're not allowed to drive. You don't have a license, do not drive. Do you understand? If you go get a license, if you get insurance, come back to me. I'll take this restriction off. That's your only condition. Don't get in trouble and don't drive. Do you understand? I'm going to have you sign an affidavit, which is a promise you're making to me. That's the only condition, Mr. Caldwell. Don't drive. Now, you have a lawyer. Remain in contact with him. I'm going to waive your appearance. You don't have to waste your time coming to court, but you must stay in contact with him. If he tells me he can't get in contact with you, I will revoke your bond. Just don't pick him a new case and be good. All right? Come on. Thanks, Mr. Caldwell. You too.
Judge, are there gonna be stage one?
No, I'm not putting any conditions, just a no driving affidavit.
Now it's approaching on page 2. Lauren?
Mr. Pruitt,
Hello, Judge.
happy Friday, man.
The one you, Ron Barnby was in jail for Fort County.
Oh, we reinstated, okay.
Here today because you wanted the bond conditions.
Good morning, Mr. Barnes.
Sorry, David.
You made it out.
Yes, I did.
Just, we're not asking for much, man. Just be careful, behave, don't do anything you shouldn't do, you know? Is those cases are still open in Fort Bend or what?
The current case is still open in Fort Bend. It's still pending. Your next court date is down there.
It's on March. Not all the cases are open.
One of them still open. Paul Two's representing him. I talked to Paul yesterday and it's set for sometime in March. I can't recall the exact
It's
date.
okay. Have we done PC on this yet or no?
We haven't done anything. He was in custody.
Right, okay, so we're gonna do probable cause. You have the right to remain silent. Anything you say can and will be used against you. I just want to see if there's enough to go forward on your case. I don't know what happened. Okay, Alex,
Yes,
please.
Judge. On September 4th, 2024, the officer observed a hand-to-hand transaction between the driver of a parked vehicle and another individual. The defendant was a passenger in the vehicle, and the officer approached and smelled a strong odor of marijuana. The officer asked the defendant to step out of the vehicle and saw in plain view a scale in the driver's side door, and the officer detained the defendant and the driver. The officer found a bag of marijuana in the defendant's waistband pursuant to a pat-down, and the weight of the marijuana was 1.27 ounces.
Telling me he saw him do a hand-to-hand transaction or someone else?
The driver of the vehicle was a hand-to-hand transaction, and when he approached the vehicle, he asked the defendant and the driver who did the hand-to-hand transaction to exit. And furthermore, the officer smelled an odor of marijuana.
I know, but why would he search him?
What?
I get it on the driver because he sees the hand-to-hand contact with them, but he's just sitting there.
The only thing would be officer safety, just the pat down. That
All right, Mr. Barnes, I'm gonna find no probable cause. Just be careful, all right? Really, you hang with dogs, what happens? No. You get flea. Well, you can get bit too, right? Get fleas.
It's a bad dog.
Just don't hang out with the wrong people, all right?
Yes, sir.
Come on.
Christopher.
Thank you, Your Honor.
Rubio?
Did you say,
Richard? David, 26.
good morning, sir. So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. So this is the one that we were talking about the other day, right? Where it looks like initially a magistrate found no PC, right? But then we have a refile the next day. Will you go ahead and read PC? You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The officer met with a complainant who stated that the defendant is her ex-husband, and the complainant advised that on August 25th, 2024, the defendant was at her residence regarding a visitation. As the two children went into the home, The complainant told the defendant to leave. The defendant then pushed his way into the home and pushed the complainant against the wall, causing pain. The officer observed surveillance footage showing the defendant push and strike the complainant in the upper chest area.
Oh, there's a strike.
Yes, Judge.
Okay. Mr. Record, I'm going to find that there's probable cause to go forward with your case. A protective order has been issued in this case. Get to know it. If you violate the protective order, the state can and probably will file a violation protective order against you. It's one of the worst cases you can pick up. You're not to have contact with this person and not to go where she lives or where she works. Do you understand? No. I can give you a lawyer.
Sir?
I can give you a lawyer if you'd like.
Yes, sir.
Talk to the lawyer and the lawyer can come up and talk to me. I just don't want you to say anything. Believe it or not, I'm trying to help you because I've got a bunch of DAs here. Whatever you say, they're going to try to use it against you. All right. Do you need a lawyer?
Yes, sir.
All right. I'm going to have you sign a receipt of Victoria. We'll have you in the jury box. If you can file the conditions, no contact, no weapons, please.
Yes, sir.
Have you signed the conditions and then we'll provide your lawyer here momentarily. Okay? Please, sir.
You need this, Judge.
No, I have one on file. Thanks.
I pointed to Mr. Richard today. It's RICHERT.
Yeah.
And he has no contact as part of his conditions in a
Correct.
MOAB. He does have two daughters with the complainant.
Court comes to order. You need to talk them out.
He wants to know if he can still go there for visitation for.
No, she doesn't want him to come over. That's what I heard. Right.
Same would be a.
Well, Judge, would you at least allow him to get a third party to pick up the daughters?
I mean,
Okay.
come up.
Maybe we could do that as sort of a middle ground.
Is it Richard or is it Reichert?
Richard.
Mr. Richard, I like to follow the wishes of the complaining witness. So if she doesn't want to have contact with you, then that's what we do. If she wants to have contact with you, then I'm fine with it. But I have to hear it from them to see what they want.
Okay.
What the state has told me so far is that they don't want, this person doesn't want to have contact with you. The last thing I want is for you to go over there, you accidentally bump into her, words exchange, you're the one that's on bond, you're the one that's going to end up going back to jail. So it's more of like a preventative measure, right? So there's no issue if you have someone else to try to facilitate contact with your daughter. The complaining witness is only the ex-wife. It's none of the daughters, right?
Correct, Your Honor.
Right. So however you want to have contact with the daughters, great. Just don't go over there. You can always use someone else to try to like be an intermediary to get them to you however you want.
So someone else could go pick up my children and bring them to me.
Sure, of course. Yeah. But that's probably the safest way so you don't bump into this person. She says something to you where it just inflames the passion and, you know, that's the last thing we want.
Is someone going to explain to her that someone else will be picking up my children? If I'm not allowed to
I guess,
contact her?
can you reach out to her and let her know that that's what we're going to try, that's what they're going to try to do so that she's aware of, you know, even leaving however you want to. Yeah, we'll have the state reach out to her to let her know that this is how the agreement that they're going to try to work, so to have someone. How old are the daughters?
8 and 14.
Yeah. Yeah, do you mind, please? Yeah, okay, so they'll reach out and do that and then, you know, hope maybe a grandparent or someone else or,
They're worse.
okay, well,
Thank you, Judge. Appreciate it.
for sure.
Good morning.
Mr. Hayes, you were charged with assault of a family member. You were facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Actually, you're charged with 2 counts of assault. You're facing up to a year in jail and or a $4,000 fine. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On June 3rd, 2024, the officers were dispatched to an aggravated assault call, and the officers met with 2 complainants. The first complainant was in a prior dating relationship with the defendant. The second complainant is the first complainant's mother. The first complainant stated the defendant and her were at a party when the defendant started to become upset, and the first complainant was not responding to his advances. The 2 got into a verbal altercation, and during the verbal argument, the defendant punched the first complainant in the face several times, causing pain. The second complainant stated she observed that the defendant and the first complainant were in a verbal argument and went over to intervene, but was struck in the face with a closed fist by the defendant, causing pain. The defendant then left and returned with more family members, and the first complainant stated the defendant continued to assault her until gunshots were heard and the defendant fled.
Hey, stop.
I'm sorry.
Do we know if alcohol played a part in any of this?
There are no allegations of alcohol, Your Honor.
Mr. Hayes, I'm going to find that there's probable cause to go forward on both of your cases. In both of your cases, protective orders have been issued. I would get to know them. If you violate the protective order, the state can and probably will file a violation of a protective order. It's one of the worst cases you can pick up. Do you understand? I am ordering you not to have any contact with either of these people at all throughout the duration of this case and not to be in possession of any weapons. I'm going to do everything in my power to protect my public at all costs. Be aware of that. If I find that you pick up a new case, you endanger my public, I will revoke the bond, put you in jail, and I'm going to make them extremely high. You have a lawyer. I don't know where your lawyer is, but because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with the lawyer. If the lawyer tells me he can't get hold of you because you're playing games, you're not responding to phone calls, text messages, I will issue a warrant for your arrest.
Okay.
For now, I'll have you sign a reset. We'll have you take a seat while we get your bond conditions, we'll have you sign it, and then we'll just wait for your lawyer to get here, sir.
And my lawyer's gonna be coming here.
I don't know. He's not here yet, so hopefully he shows up.